Good afternoon, folks. Ryan Gonzalez here with Becker Properties, joined with Carlos Cruz, my co-host from eCapital Mortgage, and Mr. Aaron Lee.
What's up? What's up?
We had him back on the show today because, he does wholesale investing and familiar with the real estate game. He has some questions for Miss Jackie Ward, our special guest today. She's a real estate attorney, and she focuses on real estate, estate planning, and real estate law in general. So we have a ton of questions for her because nobody really plans for the will and after they pass away, and there's so much confusion with what to do after someone passes. A lot of stuff goes to probate. Give us your insight on some of the biggest misconceptions with estate planning and what you see the common mistakes are. I guess let's start there, and also your background.
So just starting with my background, so I've now been practicing law for over 20 years. Primarily in real estate. I do have a large also background in oil and gas, which gave me the background to grow my real estate business, specifically in title. In doing so in title, you learn that you actually touch numerous aspects of law, specifically probate, estate planning, and business formation. And so those are really the groups that I hone in on my practice and with real estate as my overall. I found working with individuals is my love and passion, and that's what the reason why I'm here is to make sure everybody tries to plan ahead of time, and that's where we get stuck. There is no planning. People automatically think, well, we're married, so the other spouse is going to get the house when the other person dies. Well, in Texas, it may be true, maybe not. So you really have to know the law, and planning and getting to somebody that can help you can solve a lot of problems and help those that are left after you pass away.
Yeah, and we see all the time someone pass, and then they call myself or they call Carlos. They may call the title company. They may not even think about calling you. I get the question all the time, hey, my dad passed, my brother passed, or my mother passed. What do I do now? They don't know that the property doesn't automatically go to them. Depends on the heirs. Can you explain that just in a brief scenario or an example?
Sure. So the questions become of, first of all, was there a will? And or were there other documents put in place? Specifically, for instance, if there's real property, and including in real property, not just residential lots, and it also includes an oil and gas interest. And so if somebody passes, they can also do what's called a transfer on death deed or a ladybird life estate deed. And that allows a named beneficiary to get the property upon somebody's death. So, however, if there's not one of those in place, then the next question is there a will? And somebody will come to me and say, hey, I'm the executor of the estate of my dad or my mom or my brother or sister. Are you? You are only possibly a named executor and a will. A will has to be probated before it actually has any effect whatsoever. And then the court grants what's called letters testamentary, and it allows the executor to act on behalf of the estate. Until those are given by the court, the executor has no power to act. Within that will, it will name, hopefully, who gets what, when or how, and how it's divided, or if it has to be sold. But again, it has no effect until a probate action has taken place.
So regardless, with the will in place, you still have to go through the court and still has to go through probate.
Right. If there is none, and or a person chooses, the beneficiaries choose not to probate the will, then we look to the Texas intestate succession laws. And then the code tells us who gets what. And we have to actually start at the year of the person's death, because prior to September 1st, 1991, the laws were different. And we do run into these circumstances, especially when we have elderly people and one stays in the home forever, and then we find out the other has been passed away for 40 or 50 years. And we have to go to the previous laws prior to September 1st, 1991 to tell us who gets what. And then we have to determine whether it's separate property or community property, and then who's alive at that point. And when I say who's alive, was there a spouse? Were there children? Were there children outside of the marriage?
Yeah.
So it's a very complicated situation
Sure.
if we don't have something in writing.
I've got a question for you. We hear what you just described, to me, sounds extremely complex. In my brain, is that normal or is that rare? What is a normal situation, or is there such a thing?
There really is not a normal situation. It really becomes down to each individual person.
In other words, people need to plan.
Yes. If you don't plan, it can become very complicated. Because as of right now in the U.S., my question to you is, does everyone know what the divorce rate is right now?
No.
Over 50%.
Over
Yeah, over
50%.
50%.
So right now, that means there's high likelihood there's children outside of the marriage, which makes that even more complicated.
Oh, God. Yeah.
And not just alone with that, now we have individuals that are living together or have to live together because they can't afford to purchase a home by themselves.
Good point.
And then we
Right,
have
right.
joint owners. What happens when a joint owner dies? Now you're basically dealing with two estates, not just one, but two. So the easiest thing to do to plan is there's two documents that we can use in Texas with real estate. Again, as a reminder, this also goes to effect with an oil and gas interest, is either a transfer on death deed or a ladybird life estate deed that names a beneficiary of the property. And then upon the person's death, then that interest passes to the named beneficiary.
So, when should a person or a couple or a family meet with you? Is it, hey, Junior turned 18 and he's engaged and wants to buy a house at 25? Or is it after I bought the house? Or is it after I've been married 10 years?
So that's a great question. It's very important, and I always give this example. When you become an adult at 18, you are the one that's going to make the decision. Your parents no longer have the authority to make the decision as to if something happens to you. I give the instance, what happens if the individual goes off to college and they do have assets? They get in an accident and they're in the hospital incapacitated. You need, as the mother, needs to get into their apartment, but the leasing manager says, no, I'm sorry, who are you? Well, I'm their mother. Well, do you have a power of attorney? What's your authority to have access to
Jeez.
that individual's assets? So it is very important to begin at 18 with the standard documents. And then as you acquire assets, things have to change. And I recommend every 5 years or upon a life-changing situation is to actually review documents. And likely at that point, you're going to have to update things.
Updates. So what you're saying is that my wife and I have been very bad in not meeting with you sooner. Thank you. That's what I got from that.
And that's the normal.
Okay.
And it doesn't matter whether you're wealthy, whether you are only own a house. And when I tell people, it's not just a house can make you an extremely wealthy person. I put a point into this. My husband and I purchased a house in 2000 and we spent $85,000 for it. We now have 12 doors from that one home.
That's awesome.
Yeah, makes sense.
Yeah, I get it.
So it is important, and it's a need to constantly review. And just remember, I say if you can go out and buy a $2,000 phone, you can go out and take care of your business for an estate planning. And yes, my estate planning package for a married couple is below $2,000.
That's just a smart investment. Because my wife and I we were talking about it recently, and imagine if you were in a family that had different religious beliefs, right? Or different progressive beliefs. Maybe maybe we both passed at the same time, and I want to be cremated, and she doesn't want to be cremated. Now we've got who making that decision?
And that's not even, that's beyond a property, an asset. That's
Yeah.
about a person's desires.
Sure.
And
And
now we have nieces and a nephew, and we have a different path for what we want to do
Yes.
with our properties and our inheritances. And so, yeah, I think should have spoken with you sooner.
I have a question, and just because we're going to be talking about probate probably a ton in this podcast, could you explain what actual probate entails? That way, the listeners can actually know what that means when we
that's
say
a good.
it.
Yeah, because what is that?
What
word?
is probate, right?
Well, first of all, a lot of people are scared because they hear the court. Probate really isn't a scary process. Can it be long? Yes. First of all, when I get a call and an individual says, I likely need to have a will probated, my first question is, what county are you in? Because that has a lot to do with it. Bexar County and the other larger counties, Dallas, Tarrant, Travis, Harris, they're going to be the more difficult counties to have to deal with. And why is that? It's because there's statutory probate judges, and they have staff attorneys, they have paralegals, they have clerks. So there's a process that has to go through each one of them for all the documents to get approved when we submit them to the court before we can even get a hearing with a judge. And on top of the numbers of individuals that we have to deal with that are dying, the estates.
Yeah.
So with the process of probate, what happens is a person hires an attorney. There may or may not be a will. If there's a will, it's going to make life a whole lot easier because then we're not going to look at the statute. We submit the will to the court doing what's called an application to probate the will.
Okay.
The will is submitted to the court for the executor to be appointed and for the terms of the will to be followed. With that, there's a few more filings, but all in all, the process in general should only take 3 to 4 months if it's a simple no contest, no issues. And then basically the executor can go and distribute the assets and do what they need to do. However, there's other probate proceedings that can make things more complicated, and probably for time reasons, I probably should not go into, because that's pretty much a class or a podcast on its own. But if it's just a standard independent executor, it's about 3 to 4 months. Now, as again, in the larger counties, it can take longer if there's issues that the staff attorney or paralegals find that they don't like or the judge does not like, because they have their own rules within the court beyond what's required in the code.
When does it take, like 6 months to a year? When does the long probate happen?
So usually that's when we're dealing with a dependent administration or a determination of heirship. And a dependent administration is when the court has to approve of everything. So the court has to approve, say for instance, if a property has to be sold, the court has to approve the contract. The court has to approve the sell amount. The court has to approve everything.
That's not a fast process.
No. And then in the determination of heirship is basically there is no will and we have to determine who the heirs are. And
God.
Yes, an attorney ad litem may have to be appointed by the court. Not may, there will be in a determination of heirship. And so that can go from anywhere for a year to 2 years.
And they're searching who the heirs are, right?
Yes.
They're doing some research. Yeah.
They have to confirm to make sure there's nobody out there that shouldn't have any rights.
So I went through a transaction one time with this lady, and I knew her husband passed, but I didn't know he had kids. And so when we got down to it, the title company found that.
Yes.
And found that she wasn't, entitled to all the money. And so half had to be divided amongst the kids.
Yes.
And so the money she thought she was going to walk away with,
Is not what it
dramatically
is.
changed, right? So it just changed her plans completely. But the title company was able to find the children, luckily, and get them to come to the title company and sign. And it wasn't that big of a deal. It didn't take too long, but I guess we got kind of lucky on that one because it could have. Who knows?
Yes, because in those circumstances, a lot of times we have children that are upset. They may hold out.
Yep.
They
can see
think
that.
they should get more.
These guys didn't even know.
Yeah.
So
And
they're happy, but
yes, there's some that just because
Yeah.
they're like, I'm not going to sign anything. I don't care if I have this or not. And so it makes it really difficult. And that's why we always need to plan. But my suggestion always in any transaction that somebody walks into is specifically for the realtors out there is to go to your escrow officer that you work with and tell them, hey, can you do a soft title pull to verify who the owner is? And so
Yeah.
you don't walk into something and ask those 500 questions because some people, when you're dealing with them or they're going through a situation, they don't always think about
no.
what applies in the world because they don't understand or know the circumstances behind the law with real estate.
Yeah, that's definitely true. Definitely true. Carlos, you have anything?
Yeah. So going back to that conversation I was talking about a minute ago with a buddy of mine. So we have a situation where my friend's mom was involved with a man, and they cared for each other for many years. He owned a home, and the house was paid off, and he passed away years ago, maybe 14, 15 years ago. He had a will in place that upon her death, the house would be sold and the two remaining children would inherit whatever that was. And then if she chose to, she could sell the home and the proceeds would be split equally 3 ways. However, he put the deed in her name and then passed. Now, it says something like life trust. I don't know if that changes anything, but it says her name as the deed holder.
So in that circumstances, if without reviewing the deed, so 2 things, it could have fully been vested into her, into title as to her, and so that's what applies. She would be the owner. The will would no longer have any effect as to that property because the property would have been deeded out, and or she could have been it could have been a life estate, a ladybird life estate deed in which upon his passing the interest would vest into her. In that same circumstances, she would be the beneficiary of the property, and therefore she has total control over it, and then she can do what she wants with it.
It's interesting because I guess I go back to something that you and I have talked about. It's really about communication. What are my intentions? What am I doing? And then sharing that openly, because if you don't, then it does create confusion and stress and anxiety.
So I tell anybody, if there's more than one person involved, there is going to be conflict. I don't care what you say about your family. I've seen over and over and over again what money can do to families, and it is destructive. And when I say money, it doesn't even have to have any high value. I've seen things where a watch turns into conflict and destroys everything. A lot that's worth $25,000. And I have to always remind people, do you know this was never yours in the first place?
Oh, good point.
I've known a family that one of the children was given the house very clearly by the parents, but the other, they never put it in a will, and the other children knew that there was some value in the house. 2 of the children were millionaires, and all they were going to get was $5,000. And they literally fought for their $5,000, or they were going to make their brother homeless.
Yes, because they
so sad.
Yes,
Yeah.
It is, and that's why it's very important. And I try to tell my clients, yes, you can only do as much as you can, but doing this can be the greatest gift that you can give to those that you're wanting to leave to something. And all you can hope is that the individuals that you left behind will do what you ask for and not create any other confusion. But if they choose to do that, there's absolutely nothing that you can do. And just remember that they're the ones that are going to have to live with that. That's on them that caused the conflict. and the others have to decide: do I stand and fight, or do I walk away? Is it worth it? What is the worth and value of it?
I mean, there's only so much you can do, right? Because the law is the law, right?
Wishing and hoping isn't a solution.
No,
Yeah.
no.
Yeah. So, I mean, either do it, get prepared beforehand, or you're stuck fighting uphill battle.
Yes.
Um,
And it really is.
That's tough.
Texas makes it a simple process. I mean,
Yeah.
beyond just your will, your Ladybird life estate deed, or your transfer on death deed. You think about accounts. You can name beneficiaries on accounts. Those are all free things that you can do as an individual today. Payable on death. Life insurance policies. Make sure there's named beneficiaries on there, because if not, that's where the problems evolve. You can name a beneficiary for a vehicle. You can take the form offline. The DMV has the form.
Oh, wow.
Okay.
Because those are assets that have to be taken care of. So you can do all of that. It's really simple. It's just stepping out of the uncomfortable. We all have to go through this, unfortunately. It's going to happen. And sometimes it happens sooner than later for some of us. And unfortunately, it's life. Do I like, dealing with it? No, but it is a gift. It's a gift to give to others, to know that you have at least tried to take care of things.
Clarity, peace of mind.
Yes.
What are some of the biggest mistakes you commonly see with estate planning?
The biggest mistake, not having wills properly executed. As simple as the notary did not notarize the will properly.
Oh, my.
The number of witnesses.
There's got to be a certain amount.
Yes, for it to smoothly. People making changes to wills with their own handwriting versus going back to the attorney or another attorney to get them to do
So a handwritten
properly.
note on a napkin doesn't work.
That can work, yes, but
Okay.
it has to be the whole document in the handwriting of the testator.
Oh,
Otherwise,
okay.
if it's half typed, half handwritten, that becomes the problem. So it's
It's hard to prove at that point, right?
Yes,
Yeah.
yes. And guess what happens? People die that were witnesses that may or may not have known.
gosh.
And then if you have conflict, then you're going to have people out there saying, well, he didn't do that. He was forced. She was forced to do that.
So that's
So let me ask you a question real quick. Can somebody actually draw up their own will, whether it be in their handwriting or online, and get it notarized and get it witnessed, and that could be
They can.
Valid?
They can, but again, it may be harder depending upon how it was done. If there was proper amount of witnesses, because Texas has.
if it was specific?
Yes, and so.
But we all have an iPhone. Just video record yourself doing it, right?
But it's not in writing.
No, I'm saying you could video yourself
Yes,
doing it,
Yes, yes,
filming it,
Yes,
and
definitely.
then
and that is a part. Yes,
yeah.
you could do
so
that.
there's different things you
Yes,
could
there
do to help.
People always say, well, can I just pull a form offline? You can, but that doesn't mean, again, that you've executed it properly, that
Oh,
the
gosh.
witnesses are there, that the notary has. There's just steps that I always say in the business that we do, even whether it's in real estate, estate planning, you want to go to the professional
Sure.
to do that for you and make sure it's done properly. Will there possibly mistakes? We're all human and there can be mistakes, but there's less prominent and possibility for those mistakes.
And
If
you can't record a will, right? Or can you?
when you say record,
Like record it with the county once you.
oh yes, you can.
You can,
So
okay.
You can for safekeeping.
Okay, that's what I was
you
gonna
can
ask, yeah.
do it for safekeeping, and then
That way it doesn't get misplaced.
yes,
or,
definitely. Otherwise, I suggest also, if not, then make sure somebody knows where it is. But yes, you can
Yeah,
definitely.
because if you can't find the will, then.
Then we have a
So
problem.
here's a complex question. So let's say my wife and I have a will, and since we don't have any children, we put it in a safety deposit box, thinking that's the safe thing to do. But now my nieces and my nephew, how are they going to get to the safety deposit box?
That's why the communication becomes very important to your person or somewhere, or to tell. Communication is always the best thing.
What if you have life insurance? Can you give it to the life insurance company as part of the beneficiary, or
No,
or as
because
part of,
life insurance is actually outside of the will.
Gotcha, okay.
What their rules are is what the policy is. So you name a beneficiary, you should, And so then the circumstances arise. Well, what happens when a beneficiary is not on the you never name somebody? Well, we have to go back and review the policy, and then we have to then go ahead and implement the state of Texas intestate succession laws.
So in most cases, somebody like your niece and nephew, maybe they would have the contact to the attorney who drew up the will.
and or a copy, or just say, hey, this is I have a lockbox, and all of the paperwork that you need to know is in this lockbox, and this is how you get to it. Do you have to necessarily give the full details? Not unless you want to. If you want to keep those confidential because they can change.
Yeah.
So at least knowing where this stuff is the most important.
Got it.
I got a question that I'm sure everybody's interested to know the answer to. How does it work with taxes when it comes to property?
So this is always a very I'm always very careful with this question.
It all depends.
Yes.
Okay.
And I'm not a tax attorney.
Okay.
I do not practice tax law. What I always say is that you get a CPA, and not just like attorneys, not all CPAs are the same. I have a wonderful CPA, Rachel McNary, actually here local, that I highly recommend. She doesn't just file paperwork. She actually helps and advises, and that's what's important.
Okay.
But right now, people are always worried about taxes. But let me tell you, the federal income tax limit for an estate is $13.9 million right now. $13.9 million.
So, for the most part, most of our audience isn't going to be impacted.
Yes, yes, yes.
And if they are, I should know that person.
Yeah. You might have a bar to sell.
Right.
Okay, so for the most part, the person who inherits the property doesn't have to worry about taxes. Okay.
So
there's a threshold.
Yes, and also it depends upon how fast they turn around and sell those assets. And
the timeline. Okay.
That has an effect of the
Capital
valuation.
gains, right?
Capital
too.
gains.
Yeah.
And
Sure.
then if there's any
That makes
income
sense.
producing, so it
Because
is
they can
really,
hold on to it, then it becomes their property.
Yes.
And now they're paying short-term or long-term capital gains.
So
That
it's
makes sense.
really a case by case, and that's why.
That's a good point.
I don't advise to it.
I'm glad you brought that up.
And that's why you need to talk to a CPA. That's what they do. I don't do that. I take the legal side.
But if you're inheriting the property and selling it right away, for the most part,
You're usually okay.
you're usually
So,
okay.
like for example, our family situation, my family is my brothers and my sister. They're significantly older than me, and let's just say at the end of this situation, let's say my mom passes. My sister's tax exposure is very different than mine.
Exactly.
Because I'm still working.
Yes.
She's already retired.
And you're holding it for a longer.
My goal is to hold the property, not
Yes.
sell it. So capital gains does
Yes.
come into play
Sure.
here.
Yes.
That makes sense. Gotcha.
And you also have deductions, so those also come into play if there's any, if you did any upkeep during that time, paid property taxes of owning it, you had to do repairs. So, it's really a case by case. It's just like an individual tax return. Everything comes to play in it.
Let's just say somebody wants to do something simple. Let's say I'm a single dad, and I know I'm going to get my parents' house, and my son and I have, let's say, a small little house. If I just wanted to write something down and then bring that to you, what does that session look like where you and I are sitting down and talking about
Sure.
how to make that legitimate?
So usually, so I have about an 8-page, you hear 8 and it's kind of like, that's alarming, but it's really not. And it's an estate planning questionnaire.
Can I have one?
It actually is, if I tell potential clients, even if you don't come back for me to prepare these documents, it's a place for you to start. It's
Right.
a place for you to start thinking about what you have and where you need to go and what needs to be accomplished. So it's a list of assets, your accounts, your children, who you want to be a medical power of attorney, who you want to be a financial durable power of attorney. If you want a advance directive telling your physician what you would like to do upon becoming terminally ill, if there is a need for a guardian, if you have a younger child, who that guardian might be. And think about, with a guardian, it can either be for the person and for the child's estate, which means their assets, their monies, and they can be different people. And so when you come to see me, I hope that you fill that out. If not, we can walk through and talk about it, because some people really have no clue wherever to start. The questions start rolling during that time. So we will talk about what you have, what your goal is, where you may go in the future, and then go from there. But in most likelihood, it's a very simple process that in which a person will have a will, their durable power of attorney, their medical power of attorney, their directive to the physician, which tells them how they want to proceed if they become terminally ill, and then a HIPAA. And I do a HIPAA that lasts for 2 years after date of death. And people are like, well, why do I need that? Well, if something happens, say for instance, if you were in a car wreck and then you end up dying, your agent is able to get your medical records to take to an attorney if something like a medical malpractice or a personal injury accident may occur.
All of the things that you don't necessarily think about until I sit down with you.
Yes, that may happen. And then you have to end up hiring an attorney to spend that money to get documents subpoenaed, which somebody else could have got them really easy if you just had that piece of paper.
Wow.
And so for one person, if it's a single, those documents will cost you $850 in my office.
Again, money well spent.
Yeah.
Yes.
Definitely. And
If you can prevent stress for your family after you're gone.
Yeah, I was going to say that, a load off your family's shoulders after that. So when is it a good idea to create a trust? We've heard a lot about trust and wills, and can you explain the difference?
So a trust, there can be two routes. It can be irrevocable or revocable. Irrevocable means upon you making it, you can't make changes to it. If you want it revocable, then the terms have to allow for the changes. Most of the time, having an irrevocable trust is never a good thing.
When
would it be good?
Somebody that's really, there is possibly a need for a special needs, and there are only certain circumstances that they can have certain assets, and so it's basically set out in stone of what is required, and so you can't move over a certain amount, a limit as to.
So let's say I have a disabled child that's going to need life care.
Yes.
And I pass, and I have some wealth.
Yes.
But I can't give it to them because then the government will take it.
Funnel into it. Yes.
So then I could create this irrevocable trust.
Yes.
That now manages this
That's correct.
small estate.
But you still have to be careful, because when you name a trustee to manage it, for instance, when you name them, you put a name in specifically, you no longer can change that trustee. So
can you make it a law firm?
You could, but what happens if that law firm dissolves?
Can you make it layered?
You can. So it's always about making sure that that there's always situations that can destroy it, and you have to be very careful.
I just think of those flow charts we used to have to make as children, like what if, yes, no, maybe.
It is.
And it forces you to be an adult and go, wait a minute, this ain't a peanut butter sandwich I'm making.
No. And things like, yes, it is. And so you have to think about all of those. But no, in Texas, there's only a certain amount usually that have a need for a trust. Otherwise, the simple estate planning documents and preparing through transfer on death deeds, naming beneficiaries and everything can usually accomplish what's needed. And what happens usually with a trust is that it becomes complicated for a person because you have to manage it. It's like a business. You have to make sure you're moving all your assets into it. So anytime you acquire something, say for instance, if you bought another piece of property, you got to move those assets into the trust. It's just not an automatic thing. And so
the trust can't purchase property.
They can, but you have to purchase if you're buying in cash, great, easy thing. But if you're having to lend, not necessarily will a lender allow for the trust to take out that money to be able to purchase.
I just dealt with a loan where we were refinancing the property. The borrower had moved the property. We had done the loan originally a little over a year ago. she had a loan. She moved the property to a trust. Her reasons. But we were refinancing with the rates dropping. And we could not, the lender would not allow them to close in the name of the trust. We had to revert. We lost almost 3 weeks because we had to move the trust, the house out of the trust back into her name. And there were some communication delays. Should have taken only a week.
You have to
and
deed
you
it
should have
back
called
over?
me because that took too long. I could have had it to you within that day.
Trust me, we've understood that several times now.
So
Yeah.
whenever you put it into a trust, you're basically deeding it over to the trust.
That's
and
correct.
you may have to deed it back
Yes.
to do something,
Yes.
refinance.
Yeah.
Yes. And
Or-
also to know that, especially people that go into investing, they have to be very careful because there is no liability protection with a trust, personal liability. So an entity, the LLC,
An LLC.
is the one that you have to, that protects against liability.
So maybe purchase with an LLC, then move it to the trust, if anything.
So it's really, it depends upon, there's a lot of circumstances depending on the situation. And even if they're not prepared properly, people can lose their homestead exemptions if they're not written properly.
Ooh.
Sounds very complicated. So you probably want an attorney, guys.
So there's a lot of on the wholesaling side, right? There's a lot of, because of the fact that homes aren't really moving so much because of the interest rates, a lot of creative financing, wholesalers are doing trust acquisitions where they're acquiring the property with a trust. Now, one thing that's popping up that I've been hearing a lot of that I kind of want to get some clarification on is they're saying that once it goes into the trust, it will completely wipe it from the original owner's debt, like name debt to income, right? Take it completely off of them and put it on the new person. So basically like sub 2, but they're throwing it into a trust acquisition.
So we always have to remember there's a difference between title and the loan.
Sure.
Okay?
For sure.
So title is ownership, loan is the money.
Right.
Okay? So one person can be on a loan and another person can be on title.
Absolutely.
Okay? So unless they're not both dealt with, it's not going to change. Okay? So one, we can deed over a property into a trust, which now the trust is the owner, but if the trust does not refinance or buy out the loan or pay for the, pay cash for the loan,
Right.
this loan is still outstanding in the original owner's name, in which they're the ones that's going to bear the burden if somebody does not pay that loan.
Got you. And that's what I thought. Yeah. Okay.
Yeah, that makes sense.
And once you deed something over, if you deed something over to the trust is the owner. So unless you're a named beneficiary and the trustee, you no longer have control over that property.
Important to set them up right?
Yep.
Yeah.
Which goes back to what you said in the beginning. What is your end goal?
Yes.
Right.
Are you an investor or is this something that you're looking for your children or is this something looking for your spouse if you have no children? Again, what is your end goal?
And not just, it has to do a lot with now, but it also is what is your end goal? Because things can be changed. You just have to make sure that they're changeable.
Well, families change, right?
Yes.
I mean, family size changes up and down. I mean, it's just, again, it goes back to what you keep saying is start with you early, revisit that plan,
Update.
and then make adjustments as the changes happen because changes do happen.
People come in and out of somebody's life. And again, it becomes more evident today when we have the divorce rate of over 50% and we have individuals living in houses together, whether they're married or not, if they're having to share the burden of cost. And so, listen, if you're going into a joint ownership with somebody, you need to have an agreement in place as to what happens if they divorce. And when I say divorce, if they split up and they need to sell the property, because I get them all the time. And then now we have to fight and figure out who gets what, who paid in what, and everything. If you had that in place ahead of time, then that document tells us, hey, we must go sell this property because we no longer want to live together, and then we need to split the proceeds 50-50.
Yeah, I've had numerous situations over the years where, because Texas is a common law, common property state, it's just been complicated, very complicated. I don't think a lot of people know that, right? Have you
It's very easy.
As a lender, I've seen spouses not want to sign a deed when they got divorced, yet they were ordered by the court to do that.
But we also have to look back to the divorce decree and how well it's written.
Because
the problem is that divorce attorneys don't always know how property affects a situation down the road.
Favorite story about somebody smarter than the ex. So, couple.
This is a great story.
Yes,
I know
yes. So, couple was married. She found out he was cheating. And so she went to an attorney immediately. Thank God the attorney was smart and said, let's do this. If you're going to file for divorce, then why don't we have him pay all the debts and he gets the house, but he's obligated to refinance the house within 90 days into his name. Well, the young man was arrogant enough to think that he could do that. Well, she knew he had bad credit. So not only did he pay off all her debts, but 90 days when he didn't qualify for the mortgage, in the decree it said that she got the asset back.
Yep.
So she got the house and all her debts paid off, and the guy was single.
Yes. Yes.
Again, get a good attorney.
Yes.
I wonder if he even had an attorney.
Probably
He
not.
was
Doesn't sound like
probably
it.
one of those people that was arrogant enough that he thought she was dumb.
Yes. There's a lot of situations.
And maybe she didn't know, but the attorney knew.
She was
Yeah.
smart
She
enough
went
to.
to the-
She
she
was
was the
clearly
right-
smart enough to
she
get an
was-
attorney.
Yeah.
Yes. And
Yeah,
most of
that's
the times,
crazy.
both parties need attorneys because there needs to be eyes on
Yeah.
the divorce decree. And I always recommend also, if there's real property involved, is to hire a real estate attorney to review the divorce decree before it's filed to make sure the documents are prepared properly.
Because
I've seen some situations. I don't mean to cut you
No,
off,
go
but
for it.
I've seen one where the couple they'd been married for a very long time. They had a couple houses, and they just wanted to part ways. They had grown apart, and they didn't fight about anything. They said they both agreed on who the realtor was. They both agreed on what the floor of the sales prices would be, and they both agreed to split everything 50-50, and they moved out. But that's not normal.
No.
Nope.
No.
That's not. I mean, for all you know, there's children that nobody knew about. For all you know, it gets messy.
Yeah, I've been in a situation where it was a common law couple that had been living in the home. They were both paying towards the mortgage. One paid more than the other, but still, when it came down to it, and they wanted to sell, the one that was on the mortgage decided, okay, I'll give you this much. The other one did not agree, so she filed a judgment against the house and the property, and they had to settle. And so that just extended our closing and the whole transaction. And it's messy. It's messy if you don't have anything in writing beforehand.
That's exactly right.
To your point. So, and again, I don't think a lot of people know about the whole common law thing here in Texas, which if you don't know,
It's really easy to claim common law in Texas.
That's what I hear
Yes,
too.
it's very easy.
Can you explain that for the listeners?
She's like,
So-
oh,
Well,
I'm sure you have some stories.
yeah, there's a lot of stories. I don't know whether to say unfortunately or fortunately.
The fact is-
the fact is it's very easy to claim, and as soon as somebody throws up their hand and claims it, there doesn't take much to solidify it. When somebody makes a claim, you have to answer to that. You have to show evidence that is not what they're saying. So if a person comes back and says, oh yeah, we held each other out as that we were married, we had an account together.
If you file together.
If you filed
Jeez.
taxes
Oh, wow.
together as married, you most definitely are
well,
married.
as a lender,
yeah.
I'll tell you right now.
that one's
I've
huge.
Seen,
Yeah.
I had a loan where they said that they were single, and the spouse couldn't find the tax returns. Well, when she finally found them, she had been filing that they were married. And on an FHA loan, that means I now have to include both parties'
Yep.
Yes.
debts
Yes.
in Texas. And so the gentleman said, I said, congratulations, you're married. He said, no, I'm not. I said, did you look at your tax returns that you signed? You told the federal government you're married.
And you are married.
I said, welcome.
Yes.
Welcome.
now you get to get divorced.
The only thing you're missing is a ring.
Yes. Yes.
Yeah.
Yeah.
But But for real, I mean, that's really what it.
There's no those tax
So-
returns is that paper.
That solidifies it
Yes.
pretty much.
Congratulations,
I've been
brother.
in, I've been in a couple situations where the couples wanted to buy together, and they had plans to get married maybe in the future. Maybe they're even engaged, but at the end of the day, some of them had unfortunately split up, and I'm not a attorney at all, and I don't want to try to advise them in any type of way, but I let them know, hey, like if y'all buy together, just so you know, like this is common law state, so you are both going to own it if you're both, living in the home. And I kind of try to prepare them and educate them a little bit, but I also tell them talk to an attorney because that it can be a sticky situation if you don't have plans to actually get married. And
I'll go back to the rate, the divorce rate, and that does not even affect the
And I
divorce
know,
rate in joint owners.
I know.
Well, I'm
Yeah.
going to tell you something that I share with my nieces and my nephew, and whether they hear me or listen to me, I don't know. But a prenup is not a bad thing.
No, it is a great
I
thing.
mean, why wouldn't you think that it's fair, and I hate to use that word, why wouldn't you think that it's appropriate to protect yourself and encourage your partner to protect themselves?
Yes.
I mean, I had a situation where a young lady had inherited $1 million and she was engaged. And she didn't want the fiance to know about it.
You got a problem right
And
there.
I said, well, I mean,
It's a problem.
they'd only been together for 6 months and they were engaged.
Jeez.
And she
They're
at
pipe.
least asked me what to do. And I said, talk to a lawyer and talk to your family. That is not me.
Yep.
I am not the one to give you advice.
But when somebody says,
and they were
I
about to
don't-
buy together.
Yeah.
when you hear, I don't want somebody to know something, that's a problem.
Yeah, it's not a good sign.
That's not a good
That's
sign.
a red flag.
That is a
as they
red
would say.
flag.
Talk to your family, talk to your lawyer, not me.
Prenups are beautiful things, and you just have to be open about them and be prepared.
It's not a bad thing.
No,
It's not a
it is
stigma.
not.
It's not a negative. It is protecting yourself the same way insurance is. There's nothing wrong with
And
it.
going back to what you had said earlier about everybody, both sides should have an attorney. I know that for a fact with prenups because I had a past life. It's mandatory that each person has to have an attorney,
Yes.
right? So
And it
Well,
can't be the
it's-
same one, right?
No.
unless they
course
sign
not.
on.
Not-
There are attorneys that will sign, but it's you're basically. I mean,
Intermediate.
they're
Yeah.
saying they're releasing each other that. But yes, it's highly recommended that you do this with your own attorney,
Right.
your own advice to review everything. And you can't just do it the day before marriage. It needs to be prior to the marriage. Usually, a court will be safe if there's any contesting, as long as it's about 30 days prior to marriage.
well,
So I have another question. How does digital currency and also like social media accounts, if there's some value in that, how does that transfer over to someone's heirs? Is it the same way as money, assets, pretty much?
So, yes, within a will, you can pretty much name your beneficiary to any and everything that you own.
Okay.
Is it going to be an easy process to get somebody to recognize it? Your most important thing is going to be, when that will gets probated, you're going to have an order from a court, and you're going to take that order to Facebook or whoever cryptocurrency, whoever the owner is, and say, here's the order. This is supposed to be the
I
beneficiary.
can see that being difficult.
And if they don't abide by it, then you file an enforcement within court and you subpoena everything and let the court, and you ask for attorney's fees and everything because you've had to do this on part of the executor to move forward to distribute the assets. So it's just a change in thing. As we move and go along further with them, there will be more case law and more requirements when things get in writing and codes and what is required. I say, for instance, just like I have a lot of problems sometimes with the lending industry of recognizing successor in interest to a mortgage. Who can now pay this mortgage on behalf of this deceased person? Okay.
Yeah, because that doesn't go away.
It doesn't, but there's an opportunity for the heirs just to pay the loan and not have to assume the loan and become what the lending industry entitles as full successor in interest, in which they put the debt into their name and they can just pay the debt.
I just want to be clear what I think I'm hearing. So let's just say my wife and I passed tomorrow, and we wanted to pass the house to our 3 nieces and my nephew. Are you saying that there's a way, because I've got a 2.99 rate. I mean, they're literally making free money just to own it. So there's a way that they could just, because you read that clause in the loan disclosures, and it says that, you know, the lender has the right to call the note due upon death and blah, blah, blah. It's very scary words.
Yes.
So there's a way that they
Yes.
could keep that home,
Yes.
pay the mortgage, and not have to refinance it into their
That's
name
correct.
and lose that rate.
Well, not lose the rate.
Yeah,
Because they
and
can,
not lose that rate.
Yes, and those are the terms successor and interest. Those are the
Wow, that's huge.
magical words in the lending. You're not necessarily the heir, you're the successor and interest. Who has title to the property? And you become the successor in interest by showing that documentation that you're now the owner, and you have the right via federal statute that you can just pay on that note. Is it always easy? No. I'm dealing with one right now that I'm fighting tooth and nail because
We won't mention that lender's name because we've got a ongoing frustration with our lender on providing timely
yes.
responses.
Yes,
Yeah.
yes. And unfortunately, sometimes
Yeah,
it comes
unfortunately.
Yeah.
it comes down to possibly having to file a lawsuit against them in federal court because they're not doing what they're supposed to. And you got to balance. Do I file? And sometimes just filing a lawsuit is the magical thing that they somehow now want to do what they're supposed to. But it comes down to the lenders are not training their customer service agents of how to deal with them and to get them to the correct parties to be able to assist.
Well, is
in
it a
the-
choice or by accident?
Yeah.
Well,
Let's be real.
yeah,
I mean,
yeah.
But honestly, you would think if they're continuing to get paid, like it's not a big deal, right?
It's really about what's the value of the property. So do they want their hands on that property back? Or do they?
yeah, you're sitting on $1 million asset
Equity,
and you only
yeah.
owe $100,000.
Yeah.
Yeah.
Oh, yeah.
It really depends upon what's there.
That makes sense.
Yeah. Because there's some
Or a
houses.
$10 million
Yeah,
property.
yes,
Horrible.
Yes.
Sheesh.
Because there's some houses that people go 36 months without paying, and there's a reason why the lender hasn't done anything because there's no value.
They don't want it.
But there may be a house that goes 3 months behind, and they're foreclosing on it.
Makes sense.
Wow.
It's all money.
Yes.
Yep.
Bottom line.
Bottom line, yeah.
Has there been any like big legal changes that have happened in the last couple of years that you want the listeners to know about when it comes to estate planning or real
I
estate
want
law?
to
or
say
anything like that?
the big changes. Successor and interest is not like a big, but that's more. The federal laws have expanded on that and really try to put it out there to servicers and lenders on how to recognize and what they should be doing.
So helping consumers.
Yes,
Okay.
helping consumers. The transfer on death deed has not been around in Texas forever. Since 2015, it came into effect. A lot of other states had it, but we also had the Lady Bird Life Estate deed that did the same thing. But there is one note that I want to.
What's the difference between those two?
Sure. They are the same thing. You name a beneficiary, but the difference is the transfer on death deed has to be filed of record for at least 120 hours before the date of the death of the decedent, the person that has granted the beneficiary of the property. Yes, this does happen.
Wow.
I've had situations, clients called me, hey, we're trying to close on a property and the title company has told me that this is not my property. But my dad did a
Jeez.
transfer on death deed.
So-
and my first question is,
About 5 days before.
5 days.
Dang.
and it's happened, you know. So when I get clients that call me and they say, well, I think my doctors have told me I'm going to die in 24 hours.
Oh,
We are
sheesh.
not going to do a transfer on death deed. We're going to do a Lady Bird Life Estate deed. We're going to go ahead and still file it. But as soon as you sign that document, it's effective. So we don't have to race to the court. Will I race to the court? Yeah, I'll do an electronic filing. But we don't have those time restrictions like the transfer on death deed.
So why would you use the transfer on death deed if we have the other one that's
Because
effective?
the reason why is because title companies are a little more lenient with the transfer on death deed. When they hear Lady Bird Life Estate deed, in Texas we also have a different life estate deed in which the traditional life estate deed does not allow the owner to stay in control. When I stay in control, they can't lien the property, they can't sell it or whatever.
Oh, gosh.
The remainder men are an owner, but their interest does not vest. They don't get it until the person dies. But with the Ladybird life estate deed, the owner still has the capability of voiding the Ladybird life estate deed and selling the property. They can lien it, they can do whatever want. But the title company, for their liability purposes, they prefer the transfer on death deed.
Gotcha.
Is there one that you would recommend over the other?
The transfer on death deed, just because of dealing with title companies and everything. But again, my question is, what is the circumstances when you call me? If you're in the hospital and you say that you're about to die, I'm not going to do the transfer on death deed. We're going to do a Ladybird life estate deed, and we'll just have to deal with the title company after the fact.
So what I'm hearing is every adult should have your phone number on speed dial?
Yes, basically.
I'm not joking. I'm being very serious.
I do get calls from realtors at, I had a call a couple months ago in a commercial transaction in which the husband had a stroke. And he was still capable of making decisions, but this transaction was going on and it was supposed to close in 2 weeks. But they didn't have a transfer on death deed or a Ladybird life estate.
I had a seller pass away the day of closing.
Mm-hmm. Guess what happens? We got to probate the will or do whatever we have to.
And had it been very clear, the family could have moved very quickly.
Yes.
And yeah.
One document.
It's crazy.
And if that's just once that it's happened to me, I guarantee it's been happening over and over and over again.
Oh, we
It's
talked
an
about this
everyday-
last week too with you and that scenario.
Yeah, I had somebody pass away the day after signing a contract. Yeah.
Mm-hmm.
Yeah,
Hopefully they don't need any corrections. I'm not making a joke.
No, yeah,
it's because there's always that one form that somebody forgot to sign.
Yeah. No, that ended up being a whole mess because they didn't plan properly.
Mm-hmm.
There was a girlfriend, a live-in wife that was
Yes,
involved, and then
yes.
kids, and then prior kids, and then so the whole deal just fell
Blew
apart.
up.
I don't even know what happened with that. Yeah, I ended up having to
It's an
walk.
everyday thing in my office.
Yikes.
I'm sure you see a lot of situations, but what's one of the most surprising scenarios or unusual cases that you've seen recently that you can talk about?
So it's not been recently. It's been about a year. I had a individual call me, and he proceeds to tell me, I always love when I hear this. My grandparents gave me the property. Sir, what does give? Can you tell me, when you say give, what does that mean? Because I know what give means in the world of law, but your view of giving is different. Because I know what they're going to tell me. They're going to say, oh, grandma gave me the keys and said, when she dies, I can move into the house, or I'm already living with grandma. But grandma didn't do any documents to actually give me the property. It was just about moving me in, and so nothing was done. And so now this is a grandchild to include. Grandma and grandpa had 6 children who each all pretty much had anywhere from 4 to 6 kids each, in which some of them have died, some of the aunts and uncles have died. Well, in this instance, originally it was a lot. They built a house on it, and then now he has sold it. He has sold the property then, which he does not own, to a cousin who built onto the property.
Oh, wow. What a crazy situation right there.
In which title to any and all of that has not been clean. There has been no documentation.
Of course not.
From grandpa from grandma and grandpa to the grandson. All of these children have passed away, which had children pass away, and now this grandson has sold the property to a cousin.
I had a situation where a buyer wanted to buy a property. The seller was a elderly gentleman, and it was large acreage. It was about 10 acres. And his 4 children all built 4 houses on the property. None of it been parceled or separated.
Mm-mm.
None of the deed had been split out.
Mm-mm.
Well, guess what? Those 4 kids, or those 4 families had children.
Mm-hmm.
Yeah, that deal never happened.
Nope.
It didn't even make it to contract.
No.
Yeah.
everybody suddenly wanted more than they thought they. Yeah. Anyway, it was very ugly.
Everything needs to be in writing. Everything needs to be recorded if
must be.
possible. Like that's
Again, and I guarantee Grandpa was trying to do the right thing. He had no ill intent.
No. And the thing is he probably had the intent that they were going to live there forever. Nobody was going to be moving, so there was no need to do anything. But that's not the fact in the matter today.
well, people move every like 7 to 10 years
Yes,
or so.
it's just not reality anymore. It is not
No.
reality anymore.
Back in the day, 60,
That
80.
Yeah, my
was-
mom bought one house and stayed in that house for the
Forever.
last 60 years, 70 years.
Was it a lot different back 60, 80 years ago with the transfer of property and
With
how,
title.
Yeah, was it?
So
was it-
no, it was
no?
not different.
No,
The
okay.
same process, the same documents were still in effect. Were they always recorded or in writing or
On a napkin?
yeah. Sometimes you had more sophisticated things back then than what you had now. It's really about who was involved. It's really title is a historical thing. When you go back and look at documents back to, when Texas and when we started, Texas started selling off the land, you're going back to 1850. What there were restrictions, there was this person couldn't marry this person, or this person couldn't marry this color, this color of person couldn't live in this area. It was a historical thing of what it was like. And when you see those documents, you really put together what the area was about and who the family was.
That's why it might be important to get title insurance, right?
It's a must.
I'm on the fence on that statement. And
We were talking about this last week.
yeah, so one of the things that we look at in lending is really all of the costs associated with lending. And if you break down commissions and fees and costs, one of the things you look at, and the federal government's been looking at, is the cost of title insurance, which, if you look at the percentage of title policies that are actually executed versus their fee, it's pretty insane. And so Freddie Mac and Fannie Mae recently made some changes to their automated underwriting system, allowing for certain loan types to be converted through an attorney letter. And most of the 50 states are allowing an attorney letter of review of title to be acceptable, massively reducing fees. Let's say if I'm buying an $800,000 house, my total bill for title and all the title work might be $1,600. But if I go buy a regular policy and I go through the normal title policy process, it's like closer to $5,000. So these are massive fees that these title companies are making, and it's just pure commission. It has nothing to do with protecting that client. And my comment to that is, if I'm buying a house from a builder, they've already done the title work.
True.
Why am I going to spend $3,000, $4,000, $5,000 again? I'd rather get that and use that as money to buy down a better rate. That's my comment.
Yeah, and it's really circumstantial. It is, but also the problem is most people don't know how to use it or when to use it. They don't know what it is. So circumstances may arise that they don't even know that they have a policy that they may employ to take care of things like encroachments that may not have been that may have been missed through title.
Oh, okay.
And so they don't understand what that policy is, and so they pay for all this. They may have to hire an attorney, and if you don't hire the right attorney that says, hey, you have a policy that we may lean on and push liability onto, to figure out really if you need to hire me, it may be just to hire me to send a letter to the title company to say, hey, we believe this is a claim against the title policy. You need to review this and accept insurability so my client can get protected. But people don't know that, and it's about education. When you buy property, you need to educate yourself what comes along with that. Taxes, upkeep, when you buy something, it's just, you don't just buy it. There's things that come along with
Responsibilities that go with it.
Responsibilities, or you should know that when you pay this much, you have an expectation, and you do pay for things that have coverage and that can protect you. They just don't have a clue on it. But yes, there are circumstances that maybe not needed, that we could rely on a prior policy to cut down on the cost. But if you're buying a piece of property,
You definitely want some protection.
yes,
Agreed
you
there.
need something. Yes.
You used a word that I want to make sure that our audience understands. What are encroachments? So let's say I buy a home. And let's just say it's my house that I have today with an acre, and it's an old neighborhood. And so I've got an existing fence line, and I've got an existing survey. And we bought title insurance because that property had changed hands 4 times, I think, in 10 years. So we wanted to make sure we were protected.
Definitely.
Now, what is an encroachment? And how do I enforce the title policy?
Sure. So usually when you're going through the buy and sell process, you should have an attorney that reviews the survey to make sure that things are matching on the title commitment, which is basically your policy, the title company saying what they're going to insure and what they're not going to insure. So again, this could be a class within itself of teaching of what's there and what's not.
Sure.
But the goal is to review and to make sure there are no discrepancies. Okay, and if a survey shows that a fence line is not where it's supposed to be, that is an encroachment. Say, for instance, if you had the fence was moved by the next door neighbor into your property 5 feet, they have encroached on your property boundary. So at that time, if you're buying or selling, you need to determine what we're going to do about that. Do you want to buy that property as is, knowing that that person has encroached 5 feet? Or do you want to make the seller negotiate in getting an easement or purchasing that 5 feet to make sure there's no problems in the future? Because what happens if you need that 5 feet to build a pool that covers all of your backyard?
My thing that I worry about is if I'm owning that property, but you've encroached on it and you get injured, is that my bill? Is that my liability? Or, because it's technically my property.
Yeah, if I'm representing you and you fell, I'm going to say that it's your property.
Yeah.
Yeah. So, but it's
silly because I had a property in East Texas, family was buying, and the man that had owned all of the property had divided it all. Well, there was a garage that was halfway on one lot and halfway on another. There was a septic tank on one lot that was being shared by 3 of the properties. I just told the family point blank, I said, if you really want to go into this mess, go buy it. But I said, I think there's easier ways to buy a home than dealing with all of these intertwined potential noise factors.
Yes, owners. Individuals.
Well,
noise factors that are the individuals. Yes. So it's important just on a traditional sale to make sure that you're getting what you're purchasing, because people build driveways that encroach on other people's property. They put sheds on your property. You name it. There's stuff, and it comes down to also trees. What happens when a tree crosses over a fence line? Who owns that?
Mm-hmm. Yeah, we see that in titles sometimes, but also having the lender involved, they're going to require the survey, and then you have an attorney review the survey at title as well. So anybody financing the property, usually if there is a problem, we're going to find it right then and there and take care of it. Anybody buying a property cash and not asking for a survey or not requiring a survey, then they're
inviting themselves into some troubles.
They could be set up, they're setting themselves up for failure on there. So it's definitely important to ask for that survey. I mean, it's only like $500 depending on the property.
Yes, the little amount of what you're saving ahead of time and what could happen in the future is big dollar savings.
Definitely. Yep. So last week we talked a little bit about sub-2s since they're so popular, and also seller financing. Recently you helped me do a wrap on a house. Can you explain the difference between those things and how they work? What are the pros and cons? What are the liabilities for the buyers and the sellers?
Sure. So usually my first question when somebody calls me, whether it's a potential client, whether it's a realtor that's needing help with a transaction or an investor or whatever. So the question is, I have a seller finance transaction. Okay, well, what type of seller finance transactions? Because there's more than one.
Sure.
So there's the traditional, in which we know that is the, which some don't know, that the owner pretty much is the bank for the buyer. And so the loan, the previous loans, or it was just cash, everything's been paid off. There is no lien. And they're going to carry the note for the current purchaser. And so payments are going to be made to them. And then, so we need proper documentation always in all of these transactions, or there should be. Doesn't mean that it happens. And then we have a subject to. A subject to is in which another seller finance transaction in which the buyer buys the property subject to a lien that's in place. So they're not taking over the lien. They're not doing anything. The lien stays in the name of the previous owner of that mortgage. The wrap is with there is a lien in place, and then we're going to have a new additional lien in which wraps the first one. So I always say the seller's wanting some additional money for the property. Say, for instance, they're selling it for $350. There's already a note in place, but the individual can't bring $50,000 to the table, and so now the seller is going to do a second lien of that $50,000, and all the second to the subject to and the wrap, the individual of the first lien, are going to stay on hook for the credit of that loan. Mm-hmm. And so there needs to be certain documentation in place for the seller and buyer to protect them, to make sure if things go awry, if somebody's not paying, the money is not being paid to the mortgage, they're putting it in their pocket and moving along. And so I also always recommend a servicing company in those transactions to be the holder of the funds to make sure they go to the proper party.
Sure. Right. What protection does that previous owner have when it comes to the subject to and the wrap?
So it depends.
Depends on
the documentation. A
sure.
lot of times they go into these transactions and they do not have, usually the seller sometimes does not have a attorney in place. So they don't know what they're signing. They don't understand the transaction. They just hear seller finance. And if they don't have a route to be able to foreclose if the buyer is not paying, then they're pretty much, they're screwed.
Yeah.
So they have to have the lien documents to be able to foreclose if the buyer's not paying.
Both those scenarios are pretty similar. Like when you did my wrap for my seller, we had the documentation in place to where he could foreclose on the buyer if they're not making the payments to the mortgage company. And they did put a servicer in place to basically keep a paper trail of who's paying what, when it was paid.
It takes the burden off of the seller.
But it's also really important to have the servicer, because should they choose to finance that in their own name, now we can get a quick amortization schedule and confirm what the actual payoff is.
Yes.
Those little things matter down the road.
Yes, everything. It's just about documentation. Really, it's about making sure the right documentation in place. A lot of people are scared of them. You don't have to necessarily be scared of them if the documentation is in place. That's why you need an attorney involved on both sides to make sure both parties are protected. If you go to a title company and close, they're just going to prep the standard documents, and so there's no representation of either party. There is no attorney representing the seller, so there's no seller-specific documents, there's no buyer-specific documents. So it's always in the benefit of either party to have the attorney involved.
Yeah, I was glad I got connected with you, because obviously
you
have a lot of experience in this department. So you were the one that's drawing up the docs for the title company for that particular transaction, and me and the seller had talked about it. Felt like he was in good hands with that documentation. It may be a little bit more risky to the buyer in this case, right?
And can you explain that risk?
So
there's always the possibility, because we have a lien in place, the acceleration clause. In the deed of trust, in almost all deeds of trust, not necessarily maybe a non-traditional lender, there's acceleration language, and it says if you sell or convey or lien this property without our permission, being the lender, then we may accelerate the note due immediately. Okay, and I always say it says may. The lender always has the ability to do it or not to do it. And so if there's a circumstances that they get aware of the transaction and they don't like it and there's more value for them to foreclose on it, they're most definitely going to go ahead and call it due. And so then the buyer is in the position of they got to figure out, can they get money from somewhere else to pay off that original note, or can they refinance it, or what can they do to save what they've put into it? But most of the time, the lender is just really wanting to get the payment of the mortgage in place, because their ability to need to foreclose and then to resell it and everything, that cost is going to be higher than just assuming what they're getting from the monthly mortgage payments.
Yeah, gotcha. And is there a way to get around them not calling the note due? Is there
the only way around that is if they approve of it.
Okay.
And they will not approve a subject to or a wraparound transaction. They're just not going to do it. So it's really, again, going to be left to the seller and buyer whether they're going to proceed along with that type of transaction. So yes, they are risky. You have to know that in going in when you move forward with those, you just have to know that and do the best that you can and put the documentation in place to the best of your ability.
I'm glad we're talking about this, because it really is becoming more and more common these days with sellers having a hard time trying to sell their property. Maybe they need to get out for one reason or another. Maybe they don't have a ton of equity. That's where the sub 2 comes in hand or in place. You want to talk a little bit about sub 2 since we're talking about it?
Yeah. I mean, there's a lot, I guess, that kind of goes into sub 2s. What would you say? I know you talked about what would be the benefits for a seller on their side for having a sub 2 being done?
Sure. They're going to get out of having to make those monthly payments.
Sure.
But again, they're going to be still on hook with the credit. If the buyer goes along and is paying what they're supposed to, or the buyer says, I'm only going to plan on holding this for 6 months and then I'm going to sell it off, and then everything's going to get paid off anyways, then you're good. Because the seller just may be wrapped for the necessity of moving on and not having to make that payment, and or maybe they're just moving out of the country.
Sure.
So there are circumstances in which the individuals may have to do it, and it may be an option.
And the sub 2s are a little different, because typically you're not offering any type of balloon note or refinancing after a certain amount of time.
Right.
With the wrap that we did, it's a 5-year balloon note. To where the buyer either has to pay off the note or refinance it within 5 years.
Right.
It's still amortized 30 years.
Right.
But that kind of helps the seller out to not have to worry about it for the next. Maybe they have 20 years left.
20
or
I mean,
25
we
years
structure them kind of different though too.
Do you?
We can structure some with balloon payments. I mean, if the seller's like, look, man, I want to get out of this thing within the next 5 years. Usually we do 5 to 7. We try not to do shorter than 5.
Okay.
That way, it kind of gives us an exit strategy. Gives us a little bit more time rather than 3 years. Because if the rates go down and people start buying like crazy, and they do have at least some type of equity, or we can at least kind of break even, and having had that passive income coming in from the rental side, then we'll dump it and get rid of it. But yeah, it's not unheard of though. Yeah.
And from the lending side, if someone is owner financing their house, they still have a lien on it, a mortgage on it, but they can show through a servicing company, hey, it's getting paid. Can they buy another property?
So if I've sold the home and I've got proof of payment, I would start with yes with an asterisk.
Putting you on the spot here.
Because did they list it on? Did the deed change?
Yes.
Have they declared the earnings on their tax returns? On the surface, I would say yes. Again, with an asterisk. Because there is always going to be somebody that will find a way to screw it up. and I'm dealing with one right now. So not specifically exact this, but where we had a very clean transaction and we're 2 days away from closing, and there are some rental adjustments that they did that they didn't tell us about, and now it doesn't work.
It's all about the debt to income ratio.
Sure.
Yeah.
Math.
Sure.
Yeah.
Well,
Numbers.
I mean, that's all the questions I pretty much had. I have one more to end the session. Do y'all have any more questions for me?
I think really because, and I've heard of you from the industry and stuff. You're a big name that pops up, and this is my first time meeting you, which
Thank you.
is great.
Thank you.
I hope that we can build a relationship moving forward
Definitely.
and help each other out. But I know you have a lot of classes, and I don't know if this was your question too, but do you have any upcoming classes that maybe like the real estate community or anybody that's looking to further their education in that department that you'd be able to help out or that's coming up?
Sure. So I do offer classes, and so even individual groups, lenders, brokerage, people that just want to put a class together that have faces for me, not to waste my time.
Yeah.
I do this because I love educating individuals and pouring back and making my life easier when people come back for us needing help.
Sure.
So I do offer things. I'm trying to think of what's coming up. Off the top of my head, I had a class scheduled for tomorrow, but the individual that was hosting, unfortunately, came down with COVID.
Oh, no.
So that has been moved. And then I think the next week is I have one. What I always tell people is to follow me on Facebook because I always try to post those.
Okay.
But I do things, estate planning, probate classes, assumption classes, seller finance classes, things that y'all want me to talk about. I can build a class. So I have things in place already, and then I have things that I'm capable of as long as you give me some time and I feel comfortable of teaching. But I love doing it, and I love having y'all on, and I ask for feedback. I try to make it involved as possible because that's how you learn.
Sure.
If you're just sitting there listening to me teach and spill something out, you're not going to get anything out of it.
Right.
And so I always I tell everybody I'm going to look at your faces, and if I see crazy looking faces like I don't understand this or what about this, I'm probably going to call you out and say, hey, what are you thinking about? Let's talk about that, because that's how we learn.
Because we all have a what if.
Yes,
Yeah.
yes. And putting those things out there is going to help each other.
Nice.
But I love doing it. So, yeah, just let me know. Follow me on Facebook.
Yeah, well, definitely, most definitely.
Fill the rooms.
Jackie Ward.
Yes.
Ward.
Yeah. Okay, so the last question I got for you: what is one piece of advice you would give to a young person that thinks they're just too young for any type of estate planning, and doesn't know where to start?
First of all, just call me. I try to make everybody feel as comfortable. People will say they don't like calling an attorney. I'm very easy to talk to. I always people tell me you're not the typical attorney. You make people feel comfortable and welcoming. I try to be as sympathetic of a person in the position the person is coming to me in, and being understandable. I've had a lot of life experiences myself and have learned, and that is where it pours into my client. And the sooner you can do it, even if you're behind time, if you're 40, just come to me as soon as possible so we can talk about it. Put it on your schedule. Ask for an appointment. Don't say I'm going to do it. Call me, email me, text me, and ask for that appointment so it's on the calendar and so it makes you get to me. Because if you say I'm going to do it by January 1st, guess what? It turns out May 1st, and then it goes into a year, and then it just keeps on going. It's always something. But take what you learn and move it to the next thing. Learn as much as you can. Do your own research. Not saying that you should rely on everything that you're seeing and reading about, but try to fill yourself with wealth of information so you're prepared and not just at a blank stare when you go into an appointment or when you do your first home purchase.
Yeah.
And that's really where to begin.
I really appreciate you coming on.
Thank you for
And
asking.
Yeah.
Me too.
yeah.
Thank you.
Thank
It's.
y'all.
I think we all learned a lot here.
Appreciate it.
We have a lot of viewers that may have parents or grandparents coming up, that may not live too much longer, and really need some of this advice, some
Or getting
guidance.
married, or young and starting life.
That too.
It's
there's,
never too late.
There's so many life events going on right now, and future ones going on, that there's so much to plan for. People don't think about
It is.
all this type of stuff, and sometimes people don't want to, but it's the truth of the matter.
It's a need.
It's a need.
Yeah,
It definitely
it's
is.
life.
But I mean, that's all I have for you, and
Thank you.
Hopefully we can connect more and do business in the future. more.
Definitely. Thank you.
Thank you,
all
Jackie.
three.
Appreciate you.
Thank you.
Until next time, folks. Thank you. We'll see you.
Bye, guys.